A week of pandemonium, tribunal analysis, 9/11 KSM et al. Pretrials, July 22nd to July 26, 2019. Wow, what a crazy week for these last tribunals. Out of all the KSM et al. Tribunals that I've witnessed, this last week was the most intense. Welcome back to CBI News Network. I'm Linda Forsythe, and I'm here to give you a glimpse into the last week of proceedings. I traveled to Fort Meade in Baltimore, Maryland to watch them live via CCTV, where they were held in Guantanamo Bay, Cuba, at GTMO. Down at the bottom of our report are transcripts of the open proceedings that CBI has loaded onto their server, originally obtained from the Department of Defense Office of Military Commission's website. Please take the time to download each one and maybe print them out. Be aware that these are many hundreds of pages. Excuse me. For those who are new here, the United States versus Khalid Sheikh Mohammed et al. Are the pre-trials of 5 alleged al-Qaeda members for aiding the September 11, 2001 attacks. Charges were announced by Brigadier General Thomas W. Hartman on February 11, 2008 at a press conference at the Pentagon. The men charged are Khalid Sheikh Mohammed, Walid bin Atash, Ramzi bin al-Shabi, Amar al-Baluchi, and Mustafa Ahmad al-Hawasi. Please note, because of the great length and detail of the proceedings, we will bring only the highlights of the week and in-depth analysis of one particular significant day, which is July 24th. We will briefly cover all the other situations of note. Detailed information can be found in the transcript and made available for your download below and for your convenience. This past week will be of historical significance because much of notation went down, not only within the tribunal settings itself, but peripheral happenings that work together in tandem. Now, on day one of the proceedings, July 22nd, there wasn't a whole lot that went on, but of any kind of notation. On the first day of the proceedings, all 5 accused KSM et al. 9/11 attack conspirators must appear at the hearings. Otherwise, they generally historically will opt out from attending for the rest of the week, but that has been mandated on the first day of each proceeding for the month that they must attend. Okay, so a very polite Judge Cohen consistently addressed the accused as sir or mister from his first day on the job, the way he had done starting in June, and he continues to do so. Also in court today, prosecutors are pressing the judge to agree to start learning from the clean team statement witnessed in September. Some may require subpoenas. Defense teams say the idea is premature and are still investigating. Now, the morning of July 23rd, the hearings are in closed session for the entire day as Judge Cohen and the lawyers discuss disagreements on some of Judge Cohen's rulings. In addition, they will determine if a national security hearing is needed. We find out in open court on the next day that there was a great deal of heated discussion in this closed session, but stay tuned. We will let you know what it is we did find out. Now, before I go into a whole lot more, it is of importance to be aware of some background information in order to fully understand why situations transpired as they have this last week. In addition, it will help you to understand why the KSM et al. Proceedings have taken almost 19 years. But we won't go into that information yet because most are anxious to hear the report first. Historical information will be given afterwards, and you must hear it. Before the week began, there were 3 important new rulings made by Judge Cohen, and it was posted on the DoD website. Now, for your information, if you want to know exactly what those motions and or rulings were, we have a link down at the below, and it will go into detail, all the various different latest rulings. Looks like there was just put out another one on the 2nd, and etc. here. And you've got lots and lots of pages here that you can go through to look at these rulings. But with that being said, Okay, see, where was I? Be aware that Judge Cohen was assigned to replace Judge Perella on June 1st. Judge Perella was only on the case since September 2018, and he came in to replace Judge Pohl. In other words, there's been quite an evolving door of judges on the KSM et al. Proceedings in an unending history of delays and slow movement. But Judge Cohen is already making huge headway and taking charge to move things forward in a swift but fair manner. No more stalling with this guy. These rulings were key and meant to go into effect by July 22nd, the first day of the July proceedings. To remove the legalists and the legalese and they encapsulate the gist of what was said, I'm going to make this simpler to understand. Now, the first ruling, open court proceedings, will happen when questioning the CIA witness to the enhanced interrogations. In other words, for future reference, for those of you who are new, enhanced interrogations means torture. So the enhanced interrogations with Al Belushi. Note FYI, this witness is also the linguist who identified the voices in the taping of the FBI surveillance of chatter in the 118 calls for 25 lines who were planning and orchestrating 9/11 before it happened in 2001. In other words, they heard this chatter of people who were planning 9/11 almost 6 months from April of 2001 all the way to October 2001. So they want to question the CIA witness to the enhanced interrogations. They've been fighting this one for a long time. Okay, the second ruling temporarily initially hidden and in placeholder, was implemented until a response is received by the defense team. Deadline was July 22nd, when the ruling would be revealed for public eyes on whether or not the defense argument of "we weren't at war when 9/11 happened, so Belushi should be tried in federal court" argument. We will hear whether or not it was overruled. Mandated ruling to be in open court the week of July 22nd. That's what the ruling was. Now, the third ruling, another ruling temporarily hidden and on a placeholder on the DOD website, a placeholder implemented until a response is received again by the defense team. Deadline again was July 22nd, when ruling would have been made available for public eyes and mandated during the proceedings that week. This has to do with Al Belushi's information divulged during enhanced interrogations on whether or not this information should continue to be suppressed or inadmissible as evidence because statements were made against his will, or would the ruling stipulate that it is admissible and will therefore be revealed in open court that week? So we had, this week was coming up, was going to be huge. Well, the defense and the prosecution both took loud and dramatic exception to these rulings because it pretty much went into the favor of ES. And what it basically happened, in fact, the entire week was a drama fest for the KSM et al. 9/11 pretrial tribunals. The defense and prosecution were both raging for various reasons and expressing grievance against Judge Cohen's ruling, in addition to protesting the mandated discovery deadlines. The rulings given were also meant to keep proceedings open in open court this entire week. The government concerns for testimony from a CIA linguist who identified voices in the pre-9/11 chatter were overruled for closed proceedings, as these would not divulge sources and methods for FBI discovery, and the defense argument for repression of Al Belushi testimony during enhanced interrogation was also overruled. But last but not least, the team also mandated to set up a definitive date for the actual KSM et al. Trials to begin. The results of these rulings Sunday, Sunday, they added a day. So Sunday proceedings were added via defense and prosecution request in order to discuss how information would be argued in open court. Ultimately, 2 days of proceedings ended up being in closed sessions. Wednesday, which was the next day we were going to get into, remember Tuesday was the closed sessions. Whoops, I went a little bit too far here. Uh, Wednesday, July 24th, was pandemonium, and the most action-filled day as the proceedings began. Charges were brought against a defense team member, Mr. Harrington, during the Tuesday closed proceedings the day before. And Harrington mentions this Wednesday morning that he, quote unquote, guesses he'll have to hire himself a lawyer and outside counsel for what was described as manufactured outrage. So, in other words, the lawyer needs to hire himself a lawyer. I would have given anything to be a fly on the wall during these closed proceedings. After Judge Cohen took a roll call of who was in attendance, Cheryl Borman from the defense team's argument was interrupted by prosecution for ringing the bell of alarm against testimony that turned out wasn't classified, and temporarily closed the hearing with a secure session, please stand by, blue screen for approximately 5 minutes. Got a picture of it right here. What it looks like. Judge Cohen demanded an explanation from military trial counsel for prosecution, which was Mr. Tribunal, to please explain his ringing the proverbial bell for the record. Initially, he said it was to protect the identity of the CIA linguist upon his entrance into the courtroom. His explanation, I misunderstood, and he apologized to the court. But then he turned around and did it again 2 more times. So, that was very interesting. He was definitely chomping at the bit, scared to death. Something was going to come out. Well, while Cheryl was testifying in court, the defense had been arguing for the first and second time about why they felt the proceedings for repression of Al Belushi's testimony needed to stay repressed, and serious mistrust issues alleging CIA infiltration into the defense team. Now, when I give you some history after these explanations of what went on during the tribunals, you're going to want to hear this and exactly what it is she is talking about. But for now, prosecution was also fighting against the date for discovery deadlines and also argued against the order of allowing the CIA operative to be questioned in open court. Judge Cohen continued to suggest the multitude of ways the CIA operative identity could be disguised, and these methods were successfully used in federal courts all the time. Prosecution disagreed. It was unprecedented. It was crazy. It was a heated discussion. Each time the proverbial bell was rung, the following display sign would again flash up on the CCTV screen and stay for varied amounts of standby time. At a side educational note, there is a link here to a news alert on what CIA is working with Congress in order to better protect CIA operatives, which is part of the reason Mr. Tribunal was working so hard to prevent the identity of the CIA linguists here. Now, this may be of interest to you. It certainly was to me. But basically, this link will take you to this article by the New York Times, Expansion of Secrecy Laws for Intelligence Operatives Alarms the Free Press Advocates. The CIA wants the law to protect the identities of more covert officers and informants, citing its defunct torture programs and groups like WikiLeaks. Well, this is interesting because on one hand, I think we all agree, we certainly want to keep our people in the CIA who are, covertly doing their job, so to speak, and they want to keep themselves into incognito. It would be very dangerous to have their identities exposed. So I get that. But what is alarming free press is it is also suppressing very important information, which is what's been going on in this trial because of this very argument. And the argument has been with Judge Cohen, you can hide, you can disguise their voices, it can be, they can be behind a screen, they can, there's many, many ways to disguise their identities, but their testimony needs to happen in open court. And for whatever reason, the CIA, Mr. Tribunal, is flat out disagreeing. He says that in this case, the person that's a CIA operative has a very distinct accent, stated that there's a possibility that things could be recognized because of the way the voice is inflected and etc. And since Al-Qaeda is very, very dangerous and they're listening all the time, they are concerned that, not only for this person's identity, but the family and etc. could be put in danger. So that is what has been going on over and over again. This is an interesting article. If you would like to take the time to read it, the link is there in this report. Okay, so all you have to do is click there. Now, on July 25th, the majority of the day was held in closed proceedings except for a 23-minute open session for a motion ruling on whether Mr. Al-Hawasi can have access to a court-approved 2008 laptop without Wi-Fi in a 24-hour day. Mr. Al-Hawasi will only have access to that laptop for 4 hours in 2-hour increments. So the rest of the day was in closed proceedings except for the 23 minutes, and that 23-minute transcript, if you are interested, is there for your perusal. It is kind of interesting on how they're going about and securing it. But anyway, on July 26th, in order to explain to Judge Cohen the reason why these proceedings have been taking so long, Mr. David Nevin tells the judge, "We have had infiltration of the defense teams." There it is again. "I was at one point subject to investigation." That's also interesting. All these things slow the process down. KSM defense lawyer David Niven, with his client absent from court, is now addressing the judge on the sentencing question. "Torture is at the heart of this case. If the United States had never tortured his client," Nevin says, "this case would not be happening here in Guantanamo." Nevin also states, Mr. Muhammad was arrested on March 1st, 2003, and he didn't see a lawyer until 2008, 5 years later. An effective attorney-client relationship is still evolving at this point. 7 years from the arraignment strikes me differently than it does prosecution Ryan, given what happened before. Nevin is showing the court a photo of KSM's 2 sons. Maybe they're 5 and 8 years old in the picture when the photo was taken. He says his team sought discovery on the detention of Mr. Muhammad's sons and received no written material, no explanation, no FBI documentation, just the photo that he received in 2008. That was taken many years earlier. Nevin argues the defense is entitled to see the full Senate study on the CIA's rendition, detention, and interrogation program, also known as the torture report, and the millions of underlying documents. In Mr. Nevin's view, discovery is not complete. Now, this has been prevented from defense from looking at this because prosecution is saying it could disclose source and methods of things that they do and how they collect information and etc. So a lot of information to the defense is being withheld. Okay, Judge Cohen has decided that he will start holding hearings on the defense suppression motion in September when he has set the schedule for a 3-week pre-trial session. Discovery must be met before the next proceedings. Prosecutor Ryan is deviating a bit from the morning argument where he said the prosecution could meet the 701 discovery obligations on September 1st, 2019. Now he says they can do it by October 1st, building in some wiggle room for that. Ryan says the prosecution understands that there will be accountability, consequences if they don't live up to their obligations. Judge Cohen requests prosecutors to give him timelines, commitments on how fast the U.S. government can turn around security clearances. Defense attorney Cheryl Borman to Judge Cohen made the statement, "Make a hard stop. Litigate what we can. Don't move forward until the prosecution certifies that they've done complete discovery. Until they do, nothing can move forward." She also says the team needs, among other things, a medical expert on Waleed bin Attash's health situation at the time. He supposedly voluntarily confessed to the FBI agents at GTMO in 2007-2008. Borman discussing her team's needs, including more lawyers, staff. Critically, she says, when Judge Pohl suppressed the clean team statements, the Office of Military Commission defunded all her experts and has yet to reinstate them for the suppression motion due on August, well, that was due in August 8/18. Judge Cohen declares the hearing in recess until September, and with this, I have some very tough decisions to make, he says. Stand by for additional guidance. He also alluded earlier in the week that maybe the only fair decision for all concerned would be to put down a ruling for life in prison. Note, a trial date has yet to be set. No firm plan how to shape September's docketed 3-week hearing straddling the 9/11 anniversary was decided upon. So, FYI, in September, they are going to be going for 3 weeks with these pretrials, which I think this is the first time since January 28th of this year that this has happened for such a period of time. So they are trying to get through this. Now, for the rest of this is where you really need to pay close attention. The transcripts for July 22nd open hearing came out in time that evening, but transcripts for July 24th, 25th, and 26th, which were open hearings, were delayed release for over 1 week, which woefully missed their 24-hour turnaround time. What was even more interesting is that the testimony heard by all in open court was still redacted in some parts of the transcripts. Now, as promised, at the beginning of this report, we said we would update you on the history as to why KSM et al. Pretrials are taking so friggin' long. It will also help you to understand Judge Cohen's statement about the possibility of making a ruling for life in prison for all concerned. As mentioned earlier, Khalid Sheikh Mohammed et al. Is a trial of 5 alleged al-Qaeda members named for aiding the September 11, 2001 attacks. This means that each of these individuals are being tried at the same time, so the proceedings can actually take 5 times as long. Each has their own case and representation and attorneys. Now, Khalid Sheikh Mohammed was first captured, right here it says October 1st, I need to change that. That is March 1st, 2003. And also, there was a period of enhanced interrogation from March 1st, 2003, till sometime late in 2007. So, in other words, when they captured him and they brought him to Gitmo, actually they took him to a secret black ops site where apparently the enhanced interrogation took place. From what I understand, they weren't at Gitmo right away. And so, of course, there wasn't even any charges brought up for, wow, that was quite a few years, almost over 4 years before he even got there. So charges were first announced by Brigadier General Thomas W. Hartman on February 11th, 2008 at a press conference at the Pentagon. 2008 is when the first arraignment or pretrial began. Notice I said when the first arraignment pretrial began. The case was thrown out of court in 2010 because of the 2009 Military Commissions Act that made testimony obtained under enhanced interrogation inadmissible in court and were only allowed to use quote unquote clean team statements that were not derived from enhanced interrogation. Well, there's some drama going on with that too, but we'll get to that in a minute. Okay, so 2012 is the year of the second arraignment or pretrial. That's when the second pretrials began. And we're still in those 7 years later, and they're actually about to be the end of it, one way or another. So that's going to be, it's ready to go to trial, or there was a very disturbing incident that was discovered a few years ago, and it has been of major concern ever since. Since I pretty much came into this and learning about it in January of this year in 2019, I was not aware of this particular situation, but we're going to go into it here. Now, on February 11, 2015, Carol Rosenberg wrote an article for the Miami Herald, which is who she was working for at the time as a journalist. Oh, geez, I just went too far. Hold on. Okay, and explains, she wrote this article that explains what was discovered, and why now there was a never-ending saga of delays and mistrust. The CIA court-appointed linguist for bin al-Shabi was sitting next to him in court when 3 of the other defense team members recognized him from the years spent in a secret CIA prison. Both the CIA and FBI have been discovered infiltrating the defense team members. The FBI had earlier secretly questioned the accused defense team members and then had them sign a non-disclosure agreement. Okay, so this is a very necessary read, and I am going to go through this and I am going to read it because it's extremely important. So this was written in 2015, but the way she writes it makes it sound like no. So just be aware. This was about what, 4 years ago. The 9/11 translator, the 9/11 lawyers trade barbs over CIA black site translator turned Guantanamo defense linguist. Okay, Guantanamo Bay, Navy base, Cuba. The September 11th trial judge and prosecutors struggled Wednesday to find a way forward out of the startling discovery that a former CIA linguist tasked to translate for an alleged 9/11 plotter earlier worked at a secret CIA prison. Defense lawyers who say their clients were tortured in the agency's secret prison network asked to take a sworn testimony from the man. They also asked the judge to halt the intended 2-week pretrial hearing, the first since August, to conduct an inquiry and perhaps new background checks on defense team staff in the complex, which is a 5-man death penalty prosecution. About 130 people, both military and civilian, work at the office of the Chief Defense Counsel. So in other words, they want to interview and question them all. This has been so decimated. This has so decimated any trust on this team, said defense attorney Cheryl Borman, her voice cracking. We can't go forward. Army Colonel James L. Pohl, the judge said he'd hear from prosecutors Thursday on the request to question the former CIA linguist who had been working temporarily for the team representing accused terrorist Ramzi bin al-Shabi since August. A new translator who just got a security clearance on Friday was flown in Tuesday from Miami. Meanwhile, defense and prosecution attorneys traded accusations over how the contract linguist came to sit beside bin al-Shabi on Monday in a courtroom where 4 of the 5 accused 9/11 conspirators says they recognized him from their years of secret detention. In other words, where they were tortured, this person was there. And they later wind up getting a job on the defense team, and they recognized them in court. It's like, oh my gosh. The chief prosecutor, Army Brigadier General Mark Martin, said twice, and actually identically, that the assignment of the former CIA linguist to translate for former CIA captive in no way resulted from any action by any executive branch agency to gather any information regarding defense activities from any of the defense teams. His sealed filings went further, according to attorneys who have read it, and accused defense attorneys of either failing to do their due diligence about the former spy agency linguist or of knowing that he'd worked for the CIA before the Monday's hearing. So I guess what he's saying here is you guys didn't do your homework. It's not his problem. If they would have done their homework, they would have known this. War Court Arabic language linguists come from a pool of names provided by approved Pentagon contractors. They require special security clearances that allow them to work with a secret intelligence. But bin al-Shabi's lead counsel, Jim Harrington, remember that name? Jim Harrington, who was in closed court that pretty much had some charges brought up against him for, exaggerated, I don't know. He brought charges up in court because he had a cow. He said after court that he and co-counsel vetted the linguist in August, and he had no idea of the translator's previous CIA work before the alleged terrorist disclosed it in court on Monday. Okay, so I think I'm understanding why on Tuesday, Mr. Jim Harrington had okay, exaggerated outrage is what they used in what they're saying that he had. The problem is I cannot trust him because he was working at the black site with the CIA, and we know him from there, said bin al-Shabi, a Yemeni accused of functioning as a 9/11 plot deputy. Wednesday, the judge's security office twice censored around from the court to the public when David Nevin, the lawyer for the alleged 9/11 mastermind Khalik Sheikh Mohammed, was speaking. In one instance, the judge said it appeared as though Nevin was about to spill secret information but didn't. Yet the court never restored Nevin's remarks to a transcript of the proceedings. It seems to be a habit of these guys. The prosecution wants the judge to investigate the defense by reading communications between some defense attorneys and the Pentagon office that provided contractors to the pool, according to the defense lawyers who read the prosecution brief. Cheryl Borman, wants to investigate every defense team member, past and present, for undisclosed previous work, and told the judge the prosecution filing on the CIA linguist episode was an out-and-out falsehood. So are you guys beginning to see why it's complicated? There's some major stuff that happened in the meantime. They had to double check things out, and this stuff is still not sorted through. Nevin asked the judge to suspend proceedings until we can get to the bottom of this issue. The issue is the latest to beleaguer preparation for the trial of the 5 men accused of conspiring in September 11, 2001 terror attacks, and as defense lawyers see it, fodder for an eventual motion to dismiss the case for outrageous government conduct. Oh no, you did not just say that. It had already been sidelined by what defense lawyers called the FBI infiltration of their privileged agents secretly questioning team members and then having them sign non-disclosure agreements. That's another incident. To solve that question, the Department of Justice attorney Fernando Campo Amor Sanchez asked to meet only with a judge and a special independent counsel assigned to advise bin al-Shabi, Air Force Lieutenant Colonel Julie Pitverek. He wanted to exclude not only bin al-Shabi, but his lawyers and the 4 other accused terrorists and their lawyers. All objected, including Pitverek, who said, at the heart of this lies the government investigation into the activities and infiltration of the RBS defense team, using an acronym for Ramzi bin al-Shabi. Then the judge said no also. It was the FBI snooping episode that set up the week's CIA linguist scandal. Little is known about what the FBI was investigating in secret approaches and questioning of defense teams, but as a result, bin al-Shabi's earlier translator lost his security clearance and his job. They settled on a new permanent linguist who didn't arrive on this remote base until Tuesday. In between, a temporary translator who worked at the CIA black site that had been filling in since August off and on, according to Harrington, and had met bin al-Shabi earlier. But bin al-Shabi only disclosed in court Monday that he recognized the linguist from a secret prison where bin al-Shabi had been held captive before his arrival at Guantanamo in 2006. Accused accomplice Amar al-Baluchi and Walid bin Atash recognized him also, as did Mohammed. The 3 were apparently seeing the translator for the first time at Guantanamo in open court on Monday. Okay, excellent report from Carol Rosenberg, who worked at Miami Herald at the time, but is now working for the New York Times. So that gives you a little bit of background there that is rather telling. It has been suggested, as you heard earlier, that those in the know, because of this last incident, the defense team may be filing a motion and arguing to have these pretrials thrown out of court. It's like, oh, for Pete's sake, I can hear all of you now. I get it. I know it. Believe me, try sitting through these. I don't know about you, but when I heard this, I threw up my hands and rolled my eyes. For some reason, the old song called A Song That Never Ends came to mind. It's just like I can still hear it right now. I was beginning to think that this is what's happening in these tribunals, the tribunals that never end. Listen to it here for a bit of levity. I went ahead and did a link for it. It's just, Anyway, it's up to you. I could go into a long tirade right now about how these proceedings appear to be quite similar to the ongoing tactics by some to keep the court systems bogged down with endless trials, allegations, lawsuits, and appeals ad nauseum. In other words, our laws and court systems are being weaponized against us. This is ridiculous. What about all the 110,000 sealed indictments? What's going to be happening with those? Well, there's actually going to be a report that I'm going to be doing hopefully tomorrow, if not the next day, that I think you will find quite telling, very interesting information that I found out. But I'm not going to have a cow here. Stay with me here, because I do see a potential light at the end of the tunnel, and no, it isn't a train. There is some hope here. Miraculously, after the end of the last KSM et al. Proceedings, the following news report came out that Khalid Sheikh Mohammed is willing to divulge to the 9/11 victims and family members the identity of the Saudi officials and other masterminds of the attack if they would be willing to spare his life. Okay, so I'm going to play that here. It's about 3 minutes long, and I think it's very important you do hear it. Listen closely.
September 11th attacks, Khalid Sheikh Mohammed says, yeah, he'll help the victims of the attack in their lawsuit against Saudi Arabia, but there's a catch. He wants the death penalty off the table. Come in, retired Colonel Morris Davis, former chief prosecutor at Guantanamo Bay. Colonel, are you okay with this? He helps the victims if we don't kill him.
Yeah, he seems to have had a change of heart. When I was the chief prosecutor about a dozen years ago, his objective was to be a martyr, but apparently over the last dozen years, he has decided he'd rather live. So he's
well, are
trying
you okay
to
with
leverage
this?
this
As a prosecutor,
advantage.
are you okay with doing a deal like that?
Well, prosecutors do deals all the time. I just find it hard to believe, though, we'd do a deal for someone like Khalid Sheikh Mohammed, who, responsible for 3,000 deaths, that we would take that off the table in a case like this when it's such an extreme case.
Why has his trial not, I don't think his trial is over. Why not? It's, 18 years after the attack?
Yeah, it's really a shame that, particularly for the family members of the 9/11 victims, that they've been denied justice for this long. And September of 2006 was when the high-value detainees were transferred to Guantanamo, including Khalid Sheikh Mohammed. Since then, the only one that's been tried and convicted was Ahmed Gilani, who was brought to the United States and prosecuted in federal court in New York. He was convicted back in 2010 and is doing a life sentence. But KSM and the others have floundered in the system down at Guantanamo, and there's just no end in sight, which is unfortunate.
Is the trial not over because KSM was waterboarded, and so any evidence that may have come out of that waterboarding cannot be used? Is that why he's still in prison, untried?
That's one of the reasons. I think there's a multitude of reasons why. In my opinion, having looked at the evidence years ago when KSM first got to Guantanamo, there's ample evidence to prove his guilt beyond a reasonable doubt without using anything he has said since he's been in our custody, which doesn't excuse us for engaging in torture, but it would make that irrelevant if we don't need to use it. So I think we could try this case successfully without using tortured evidence.
Have you met him?
I haven't met him in person. I was there during some of the interviews with some of the team members that worked for me, and I watched on closed-circuit television, but I never met him in person.
What's his demeanor?
Well, at least back then, he was a very arrogant, very proud person. To me, I've debated this in my own mind over the years, whether the death penalty is the right thing. That's what he wanted back then. I think for him, the ultimate penalty is being irrelevant, because he's a very proud, very arrogant guy, and I think the notion of spending the rest of his life being totally irrelevant is the worst punishment imaginable. So this 9/11 case and the opportunity to be a witness in that, for him, gives him some renewed relevance, and I really hate to see that happen.
Yeah, I'm with you all the way. Colonel Morris Davis, thank you very much for joining us.
Okay, so see if I can exit this full screen here. Okay, trying to figure out how to do this. Okay, there's got to be a way to do this. I'm stuck. Okay, I think I got it. All right, thank you for your patience. So going back here, let's talk about this a minute. We do have a couple of other links that, if it's of any interest, that you may want to listen to. Things we've played in the past, where Leonard Bacani had done a report on March 25th proceedings, where they talked about all the various different people that were what was recorded during this was pre 9/11. And one of this is a reminder, things that were heard were not only all these other individuals, but there was also a institution that was there representing. So with that being said, if Khalid Sheikh Mohammed is willing to divulge information on who else he was working with, and I have some pretty strong suspicions on exactly who that was, because it is out of Saudi. Remember that there were a number of Saudi dignitaries, heads of state, etc., that were put under arrest, and one of them was Al-Walid. And he has huge amounts of ownership of things all around the world, from banks to everything imaginable. This is just pure speculation, but I think it's pretty safe to say that if Al-Walid and some of these other people are mentioned, this could very well be the domino that starts to fall very quickly, along with other information that's going to come up all at the same time, mind you. It's not just going to be this information, but all this other information and proof. It's all going to come out at the same time. That's going to lead to potentially other individuals within our government and etc. But I also think, personally, that we are looking at other individuals in other countries too. So this could be a lot huger than you could ever imagine. But they are doing this because, and I have a link here, that there was the family members and the victims of 9/11 had sued in federal court that they wanted the names, which the CIA is aware of what the names are, and the FBI are aware of the names. They wanted those names released. That they want to know who else was heard on these recordings. They want the names. And so they're just plain not giving it up. I have that link here if you wanted to listen to it, which we had played a couple of times. It had to do with the report that came out with Fox News saying that this is proceedings that was going to be happening in federal court. And then we couldn't find about any proceedings after this happened, even though it was mentioned in the Fox News report. Well, this obviously has been going on. And so at this point in period of time, after these proceedings, after all this has been going on, this has been offered. So I'm sure strategically, that's why they did this. So, okay, that being said, there also is some breaking news that came out of GTMO yesterday that is above and beyond this. It's actually happened yesterday morning. There was a DC GTMO war court flight that was canceled and rescheduled for today. It says tomorrow here, after the charter aircraft was struck by lightning and then grounded in Miami. There were no hearings scheduled this week, and this particular flight was to support attorney meetings. Sheesh. This is the second interesting GTMO flight issue in a couple months. The first time, which was on May 4th, the flight slid off the runway into the water, and it was in the middle of a storm, and I guess it was pretty horrific. Nobody died, thank goodness. But there is an article link here that explains to you exactly what happened during that time on May 4th. But it's getting a little spooky out there. I mean, struck by lightning, really? And closing this report, I would like everyone to know that I'm on my knees in gratitude to our Seavine family that has they've stepped up in a mind-blowing way to help me cover these last tribunals. I mean, wow. Because of your love and encouragement to stay strong, I was able to view and report on the tribunals live. I'm not talking about just financial support, but prayerful support and volunteer workers behind the scenes. Seavine is really coming together as an incredible global family that all has the same love and mindset of just coming together to get our world back, so to speak, our families. This really has become a spiritual battle that can be exhausting, and it has been causing battle fatigue within our ranks. All of us continue to uplift each other throughout this storm. Mutual support is essential because it's crazy. It's crazy. I was able to secure lodging, and I purchased one plane ticket to fly across the country, and it was purchased on faith and believing the rest would show up to bring me home. And of course, the way was shown. God is good. We are truly the Seavine White Hat Brigade, and I love all our Patriot digital soldiers. There are two ways to donate to the Seavine Foundation, either by joining our White Hat Brigade or from the donation page, where any amount is appreciated. It is up top in the taskbar on this link. Now, here, in case you haven't scrolled down yet to see these, are the links to download all the downloads and read the KSM et al. Transcripts for the week of 7/22 to 7/26. A lot of pages. So if you want to print those out, that would be something. This will give you more details than we gave you today. But as you can see, there's a lot of information. Well, thank you, everybody. Thank you so much for stopping by. And please hold on for the next report that will be coming up tomorrow or the next day, having to do with more information that I have found out, not only about the tribunals, but about GTMO. I think you will be interested in this. Good day, everybody.